that if you look at all the literature on mining around the world, you look at all the World Bank studies and the rest of it, you will see that regulatory predictability and certainty are second only to geology when it comes to investment in the mining industry. There's a very simple reason for that, and that is that mining is a long-term, high-risk, capital-intensive business where there are very long lead times between exploration and production. And if companies don't have security of tenure, they do not have regulatory certainty and predictability, they will simply not invest. The government imperfectly, but does recognize this, because no less a person than President Zuma at the launch of Operation Pakisa last year said that the mining sector is extremely strategic to the South African economy, and he recognized that the sector was facing acute challenges, partly, as he said, a result of dramatic drop in commodity prices. There are 2 points about that. One is we haven't heard very much further about Operation Pakisa, which was launched amidst much fanfare late last year, and the results of which are not yet public. Commodity prices have followed a very precipitous fall since 2011, when the commodity prices started to fall, and this has been seen in the huge decline in FDI, foreign direct investment flows, into Africa in the last year, where they fell by 31% in 2015, fell by 21% in Mozambique, 27% in Nigeria, but most alarmingly 74% in South Africa in 2015. And FDI last year was down to $1.5 billion US. That shows you the relationship between commodity prices and FDI, and that's obviously had a huge impact on the South African economy, because mining is so central to this economy. It's estimated that mining is something like between 5 and 8% of GDP, but it's 60% of South Africa's merchandise exports. So any decline in commodity prices has a direct impact on the trade balance, the current account, has a direct impact on fiscal revenues, has an impact on the fiscal deficit. So you can see that, because in fact last year mining was something like 10% of tax revenues, and obviously once commodity prices decline, tax revenues decline with it. And with this collapse in commodity prices, there have been huge job losses in the South African mining industry, which something like 145,000 job losses between 2011 and 2015. Now, the World Bank have looked at this issue, and some of you will know that they came up with a report earlier this year and said the following, that in addition to the collapse of commodity prices, domestic factors and policy missteps contributed to the slowdown, that some progress was being made, but infrastructure bottlenecks in power, rail and ports constrained production, exports and investment. Labour relations remain fractious. Increased policy uncertainty exemplified by debates over laws on investment rights, land reform, petroleum and gas exploration have all eroded investor confidence. So those are all concerns. And those of you who look at the Fraser Institute survey, which comes out every year around the time of the mining conference, PDAC mining conference in Toronto, will see that South Africa's overall investment attractiveness this year is 66 out of 109 countries surveyed, compared with 39 out of 109 for Botswana, and 33, interestingly enough, out of 109 in Namibia. And when you look at the Fraser Institute report, one of the important things to look at is the regulatory attractiveness of a country. South Africa scored 85, it was 85th out of 109 countries surveyed on that score by Fraser, compared with position 30 out of 109 for Botswana, and 38 out of 109 for Namibia. So there's a very interesting research report which the Brenthurst Foundation put out about 2 months ago in April, called the Zambezi Protocol. I don't know if any of you have looked at it, One of the things I think that I found most striking about it is that if you look at the 1980s, South Africa's share, according to Brenthurst, of global mining was 40%. It had 880,000 jobs in the sector. By 2014, it declined to 4.5% of global mining production and under 500,000 jobs, which I think tells you a great deal. But what is equally interesting is that, and this is the key thing, because the relationship between exploration and mining, in 2011, South Africa's global share of greenfield mining projects was just 5%, compared with Australia's 38%. And there was a report in 2010 by Citibank which talked about the fact that South Africa had the most valuable mineral deposits in the world, $2,500 trillion. At the time, Citibank said that with the right regulatory environment, South Africa could double platinum, iron ore, and coal production within 5 years and add 100,000 jobs a year. And actually also made the point that South Africa had more gold underground than had actually been mined. If you look at the Botswana figures, if you go back to the Fraser report, Botswana is always consistently the highest ranked mineral producer in Africa. And the question is, how did Botswana get there? And I think there is an answer to that, and that is in its mining code of 1999. The Mines and Minerals Act of 1999 of Botswana is rated as the best mining code in Anglophone Africa. And one of the reasons it is like that is that a mining right is granted if the applicant for the mining right is able to ensure the most efficient and beneficial use of the mineral resources in the proposed mining area, in addition to having all the relevant technical competence and does not have a debt to equity ratio of more than 3:1. And so the test is whether or not an applicant is able to make the most beneficial use of the mineral resource in the area. And other than that and the technical requirements, there are no subjective discretionary requirements in the grant of a mining license. And I think that is, and the minister can only suspend or cancel a mining license on very clear grounds. So I think that gives you some indication of how Botswana's got the position it has. But I think the other country to look at in the developing world, although it's not really a developing country anymore because it's joined the OECD, is Chile. You compare Chile, and this also comes out of the Brenthurst report, with Zambia. They're countries with very similar population sizes, very similar territories, but GDP in Zambia in 2011 was $27 billion. In Chile it was $258 billion. Copper production in both countries in 1970 was more or less the same, 684,000 tons. But in 2012, copper production in Zambia was the same, it was 675,000 tons. Chile, it was 8 times more, it's 5.3 million tons. And how did that happen? Well, that happened because of free market reforms led by the government in the 80s, but also on the mining front because of the investment law in 1974, where there is effectively a contract between the investor and the state of Chile. Free trade zones were created. Policies were implemented guaranteeing the remittance of profits and capital. Free choice around foreign ownership and non-discrimination, and tariff liberalization. But the other interesting thing is that Chile also embarked on decentralization of collective bargaining, improving transparency in union voting, and allowed greater choice in union membership, and reforms of the pension sector. So those are all, and the other thing about Chile, which I think stands out as well, is it is always consistently rated in terms of Transparency International's Corruption Perception Index is one of the least corrupt countries in the world. It's in the top 20 consistently. So I think that shows, with the right policies in place, what a mineral producing state can do. On a positive level, because these are all, I suppose, will be seen as a bit of a critique, I think one should recognize it was a positive move by President Zuma to refer the MPRDA amendment bill back to Parliament at the beginning of last year on the grounds which he did, because those grounds raised rule of law issues around the definition of this act. It raised international trade law issues, South Africa's compliance with its international trade law obligations, and it raised very important procedural issues. The ANC itself, at its not this last weekend, but the meeting before that, its National Executive Committee resolved, and I think this is important, that, and we could see how this plays out in due course, that the mining charter should not be seen as a legislative instrument, while asking the parties to withdraw the Chamber of Mines to withdraw its court application. It also said that the mining charter, and I'm quoting, should not be part of the Act, but should form part of regulations in terms of the law that will ensure that the passing of the amendments to the bill are not further delayed. So I think that may be a straw in the wind, that the governing party has seen that using the mining charter as a sort of blunt legislative instrument should not pass muster, and that process, which we've seen in the latest iteration of the charter, should not be allowed to continue.
Just on the issue of the NEC, you indicate that it could mean that the charter doesn't come under the MPRDA as an act of parliament, but it comes in the regulations. Isn't that also still putting us where we were before?
No, I think you make a good point. You simply make the charter a regulation. That doesn't really solve the problem. It still becomes a legislative instrument. But charter could never really be a regulation, because if you think about the mining charter, how it was originally envisaged, it was really an agreement between government, labour and business. You go back to the 2002 charter, it was a tripartite agreement, and that's quite frankly where the whole thing's gone wrong, because if you look back to 2002, it was that agreement which was signed by government, labour and business, so all three parties undertook obligations to transform the industry. The 2010 charter moved in the direction of something which was more top-down, but the industry still agreed to it, except for the issue of historical transactions, where they didn't, and that became the subject of the Chamber of Mines court application. But the latest version of the charter is a more extreme version of the 2010 charter, and it's very much stick rather than carrot, whereas if you look back at the 2002 charter, it was a much more consensual tripartite type agreement, and I think we need to revert to that. And I think the hope I see in the NEC statement is that the charter shouldn't be a legislative instrument, it should be more of a policy type document. I mean, you can read it two ways. I mean, if the charter is going to be part of the regulations, then that is an issue. But if the charter is separated from the MPRDA and it doesn't become that legislative instrument, then I think that's a step in the right direction. And maybe what the NEC are trying to do, and I certainly, when one tries to interpret this, is persuade the Chamber to drop the court application, but say at the same time as a quid pro quo for that, we will take a different approach to the mining charter. It will become more of a policy document, which is what it should be. The President himself, in referring the bill back to Parliament, said the charter should not be cannot be part of this Act, can't be part of the Act, because it's not law. And the danger with the charter in its current form, in terms of Mining Charter 3, is it does become part of the law, and effectively the Minister or the DMR can change the rules overnight. You can have Mining Charter 4, and it becomes a legislative instrument rather than the policy document that was originally envisaged in 2002.